Redefining diversity, competence, integrity, and work ethic through one location, one phone call. Introducing Signature Hill.
Thank you, Angelo, and it's a pleasure to be here this morning. And Larry Folletta and I are going to work through what we think is going to be a valuable component of this presentation today, and that's the concept of sentence advocacy. And we're going to look at it from a couple of different perspectives. Certainly, my perspective is one of a prosecutor. I spent 2 terms as the District Attorney of Lawrence County. I just completed a 6-year term on the Pennsylvania Board of Probation and Parole. And in the work that I've done, coupled with the work that Larry Folletta has done as a federal DEA agent, it gives us a perspective of the sentencing process that I think is unique. Certainly, I've had the responsibility of putting people into prison, and I've had the responsibility for letting people out of prison. So I've seen this process from a couple of different important perspectives, and certainly the work that Angelo is doing with regard to substance abuse is extremely important. You know, I would suggest to you, and some of you work in the field, that literally 80% of the people that I saw as a prosecutor and I saw as a parole board member had some substance abuse. Many of those people, unfortunately, also had dual diagnosed problems of mental health issues and substance abuse. So the work that Angelo is doing is very important, and I'm happy to be here to participate in this conference today. What I'm going to do really is talk to you about, and I'm not sure how those are going to click in for me, but talk to you about first kind of the evolution of the right to counsel and effective representation. And really to do that, I'm going to go back about 80 years, and actually there's written materials right there that if we could pass those out and you can follow along. And we're going to try to move along as quickly as we can. I know that there are other presenters and that you have other things that you want to do as well today. But going back 80 years, you know, in this country, someone charged with a crime wasn't even afforded the right to counsel. And it wasn't until a case known as Powell versus Alabama, in which was kind of the prototypical Southern racist prosecution. Powell was one of what was known as the Scottsboro Boys, 9 African-American men who were charged with raping 2 white females. They went to trial without an attorney, an all-white jury. It was a rush trial. It was actually, there was attempted lynching. There was a mob crowd that these young men had faced. And they also faced the death penalty because rape at that time was a capital offense in Alabama. Their case ultimately made it to the Supreme Court, and the Supreme Court at that point said that the United States Constitution, due process required in capital cases that an individual, if they request it, be appointed counsel, whether they can afford it or not. So that was the first time, really, that the Supreme Court said that you're entitled to representation by counsel. It was about 20 years later in another case, Betts versus Brady, where the issue of counsel for anyone charged with a felony came before the Supreme Court. And actually the Supreme Court at that time said, no, you're not entitled to counsel if you're charged with a felony. They said absent illiteracy, and this is the Supreme Court opinion, absent illiteracy, stupidity, or a complex case, you're not entitled to counsel. And it wasn't until 1963, in the case of Gideon versus Wainwright, and I think I popped to, yeah, yeah, I'm not sure where there's one slide missing, but in the case of Gideon versus Wainwright, which is, yeah, those three cases, Gideon versus Wainwright, a landmark case, a watershed case, really, in American criminal justice. This is the 50th anniversary of Gideon versus Wainwright, decided in 1963. Clarence Gideon was a drifter, a petty thief who was arrested in the state of Florida, and he had asked for counsel. He came to the court with no money, no resources, and the judge told him almost apologetically that the law in Florida says that you're not entitled to counsel unless you're charged with a capital offense. And Clarence Gideon told the court, I think the Supreme Court said that I'm entitled to counsel. And he went to trial himself, was convicted, and ultimately his case made it to the Supreme Court. And ironically, at that point, the United States Supreme Court appointed him counsel for his Supreme Court appeal. And the counsel that they appointed to him was Abe Fortas, who became a Supreme Court justice himself. And I had a chance to listen to that argument, and you know, Abe Fortas is very learned lawyer at the time, and very deliberate. And if you listen to his argument, it's really interesting. And one point that he makes in the argument is that Clarence Darrow, who was probably one of the most famous criminal defense attorneys in the history of this country, he had been arrested. He got in some criminal trouble himself. And Abe Fortas said to the Supreme Court in his slow, deliberate fashion, he said, do you know what Clarence Darrow did? He hired a lawyer, is the way he said it. And he did. So it just gives you an example. Here's the best defense attorney in the country. He hires a lawyer when he gets arrested. And the interesting thing about Gideon versus Wainwright at the time was that it wasn't that shocking across the country that the Supreme Court said that everyone who's charged with a felony is entitled to counsel. And the reason being was, at the time, 37 states had either a statute on the book, a rule, or a court decision that said that indigent defendants were entitled to counsel. Another 8 states did it by practice. They just normally appointed a counsel for someone charged with a felony. So there are only 5 states, North Carolina, South Carolina, Florida, of course, Mississippi, and Alabama, that did not provide counsel for indigent defendants. So it wasn't really as earth-shattering a decision at the time. What was happening in the country was basically confirmed by the Supreme Court. Later, another 20 years later, the court in Strickland versus Washington said, not only are you entitled to counsel, you're entitled to the effective assistance of counsel. In that case, Strickland was charged with murder. He was convicted of first-degree murder, sentenced to death, and he suggested that his lawyer did not present mitigation evidence on his behalf during the penalty phase of his trial. And what that means is there were things in Strickland's background that he thought might convince a jury not to sentence him to death. And that's important, and is going to lead us in what we're going to talk about in a moment. Mitigation, you know, presenting a profile of your client to the court that puts your client in the best possible position to succeed or to seek alternative sentencing and things such as that. Well, what the court basically said was that if a lawyer is deficient in the way that they present their case, or in this case mitigation, and that deficiency is prejudicial to the client in the outcome of the case, then they're entitled to a new trial. They set that standard in that case, but actually Strickland didn't benefit by it, because the court found, here's the standard for the future, but your client didn't fall below that standard. So Strickland was executed about 2 months after this decision that became a landmark decision in the courts. So that moves us to about 25 years later. I don't know why we're... Yeah, go back to those other two cases if we can. Back to the other cases. These two decisions came down this year. And basically, what these decisions did was take Strickland a little further and take Powell and Gideon a little further. And what I mean by that is what Fry and Cooper said this year was that the Sixth Amendment does not only protect a defendant's right to a fair trial, it also protects a defendant's right in the pretrial proceedings, such as plea bargaining. So to give you some perspective, in the past, if you refused a plea bargain for your client, or you didn't even tell your client about a plea bargain that was offered, as long as you went to trial and had a fair trial, everything that happened before that, the court said didn't matter, because all the Sixth Amendment did was ensure that you had a fair trial. Cooper and Fry says that now the Sixth Amendment protects plea bargaining, and I think that's very important for lawyers. In these two cases, in Cooper's case, it was poor advice in the plea bargaining process. What happened in Cooper's case was he was a defendant, he shot a guy, and he shot him in the legs multiple times. And his attorney advised him, well, you know what? They can't really get you on attempted homicide because you didn't shoot him above the waist. I'm not sure where he got that, but it was completely wrong. His client relied on it. He went to trial and was convicted. In Fry, there was a plea offer made to the defendant. His attorney never even told him about it. He went to trial, got convicted, got a hefty sentence. So in those two cases, the court said that's ineffective assistance of counsel at the plea bargaining stage, and it's now protected by the Sixth Amendment. And I think those are extremely important decisions for lawyers who are practicing criminal law. And we'll try to get it. The last case I want to talk about is Miller versus Alabama, which is another case that was decided this year by the United States Supreme Court. And what the court decided in Miller versus Alabama was that life in prison, mandatory life in prison. They struck down mandatory life in prison for juveniles convicted of first-degree murder. So in Pennsylvania, for instance, if you were a juvenile charged as an adult, convicted of first-degree murder, you had a mandatory sentence of life in prison. In fact, Pennsylvania has more juveniles serving life in prison than any other state in the country. There are about 480 juveniles or people in state prison who committed first-degree murder as juveniles. The Supreme Court said you can't do that. You can't make it mandatory. You can still sentence a juvenile to life in prison, but it can't be mandatory. And what's important about that is that to deal with that decision, the Pennsylvania legislature passed a bill this summer which said that if you're 15 or older, you could get 35 years to life. If you're 14 or under, you can get 25 years to life. But what they also said was, specifically in the legislation, that there were things that the court must consider when making a decision on juvenile sentencing. So they must consider age-related characteristics like mental capacity, maturity, criminal sophistication, criminal history, institutional conduct, and any other relevant factors. So basically, what the legislature did is they wrote in a requirement to consider mitigation. The judges must consider mitigation. And what that means is that lawyers must present that mitigation. So I see the future, especially in juveniles charged with first-degree murder, a lawyer will have the same responsibility that a lawyer has in a capital case. When an adult is charged with first-degree murder, you have that responsibility to present mitigation. If you don't do that, I think it'll be ineffective assistance of counsel. And there are other commentators who believe that. There's a professor, Beth Caldwell, who said in an article just this year that it's incompetent for counsel to fail to present this information to a judge charged with determining a young person's fate. So when we look at these cases in total and this progression over the last 80 years, your right to counsel in a capital case, your right to counsel, your right to effective counsel, your right to effective counsel at plea bargaining, and your responsibility by law in Pennsylvania to present mitigation on behalf of a juvenile really sets us up for what I think is something that every lawyer is going to need to do and to do more effectively, and that is to advocate at sentencing. I don't think that mitigation is really an issue just for death penalty cases. Fry and Cooper make that clear. The idea of sentence advocacy is really preparing a detailed profile on behalf of a client, someone with the skills, the background, education, and experience to provide credibility to those specific issues, and then advocate for an alternative sentence that promotes accountability, public safety, and system efficiency. And really, system efficiency is an important component of this. And when I talk about system efficiency, what I'm talking about is dollars and cents. Right now, in Pennsylvania, with the justice reinvestment in many states across the country, policymakers are looking for ways to decrease prison population, to find alternative sentences, to save on those costs, because obviously, as you may well know, the costs of incarceration have soared in this country, and a great deal of money in Pennsylvania and states across the country is spent on housing and warehousing inmates. And I think at this point, policymakers are looking for alternatives, and sentence advocacy is one way to do that. Why hire a sentence advocate? There are a couple of reasons. Number one, in Pennsylvania, as with the federal government, and the lawyers in here will be familiar with United States versus Booker and Blakely versus Washington, which said that the federal guidelines are not mandatory. The sentencing guidelines are not mandatory, that they're advisory. And actually, there's case law in Pennsylvania, Commonwealth versus Holliday, which says that the sentence guidelines have no binding effect. They create a presumption in sentencing. So you can advocate for your client at sentencing, even with the Pennsylvania sentencing guidelines. And there are a number of different situations where I think sentence advocacy is essential for your client. Number one, plea negotiations. How do you effectively negotiate a plea if you don't know the complete profile and background, all the mitigation, all the factors that are important for a judge to make a decision, if you don't know those at the very earliest stages of the case? So you can sit down with a prosecutor with a package and say, look, here's my client, here's his history, whether it's substance abuse, whether it's abuse as a child, whether it's mental health issues, whether it's other physical trauma that can contribute to his criminogenic way. So there are a number of reasons why you'd want to have that at a plea negotiation. Certainly, if you have a client who's convicted at trial, you want to be able to present that kind of package to a trial judge who's going to make a decision on the punishment in a particular case. Cases where it's an open plea. Sometimes, strategically, a defendant pleads guilty openly, which means there's no real plea bargain. There's no specific time. There's no charges. You're going in front of the court, and you want to argue for a specific sentence. Sometimes there are situations where a prosecutor and a defense attorney both agree to a certain sentence, but they're concerned about whether the judge will accept the terms that they've negotiated. So a sentence advocate can come into court and make a presentation about why this is the best sentence for a defendant. There are cases, parole violations, parole violation hearings. When someone's violated their parole, those issues are left open. And often you go into the court not knowing what your client's going to get. So you want to go into court prepared to argue for a specific sanction. But there are also other reasons to use sentence advocacy. Larry and I have worked together on a case that is actually going to be a parole violation that we're going to deal with very soon. Again, going into court, putting the best package together for that specific client. In the case that we're dealing with, employment is the issue. So we've done a great deal of research and presented scientific studies that show that employment, training can have an impact on someone's recidivism rate. So that's the kind of work that can be useful. Number one, what you're going to do, and I've listed them here, is make recommendations for alternative sentencing. Larry is going to talk about some of the work in terms of risk assessment. Because as we said, a component of this is not only the financial aspect in some situations, but also public safety has to be a number one priority, and explaining to the court why this particular defendant, if released early, if having a shorter sentence, if having a community sentence, would not be a threat to public safety. The most important thing is compiling information. Police reports, criminal history, court transcripts, information from bail hearings, from preliminary hearings, from pretrial proceedings, all these different areas that would have any pertinent information, is accumulating that information. Interviewing the defendant, interviewing people who know the defendant, having evaluations done. In my work on the parole board, we used many evidence-based tools to assess risk and assess other aspects of defendants. Just to give you an example of a couple that you may be familiar with, the Texas Christian University drug screening test. Every inmate who's considered for parole goes through this assessment, which gives you a numerical score about their drug and alcohol problems, and also is used for treatment. There's another risk assessment tool that we use. It's called the Level of Service Inventory. And it was originally created as a tool to determine what treatment plan an inmate should have in prison, but it's evolved into a risk assessment tool. Gives you a numerical score about this person's potential risk. Those are important factors that you'd want to put into a sentence advocacy packet that you would provide to a court. Really, it's about helping defendants help themselves in a lot of ways. A sentence advocate can structure a plan for the court that a person will participate in certain treatment, in certain counseling, provide written verification that they show up for work, that they're participating in any education program that they're required to participate in. So there's a number of things that you can do. It's almost like, in some situations, an alternative to what the court is going to hear from adult probation. It's not necessarily a confrontation with adult probation or an alternative to a pre-sentence report. In fact, in a lot of situations, if you do this work early enough, you can present all this information to adult probation, and actually ask that they include it in the pre-sentence report that's provided to the judge. And in fact, if they don't, under Rule 703 in Pennsylvania, you can object to the court that you've provided information to adult probation that they haven't included in their report. So there's a lot of important things that you can do for your client to increase their chances of being successful at sentencing. You know, we'll see. Testifying as an expert. You know, can a sentence advocate come into court and testify as an expert? There are a couple of cases in Pennsylvania that are important. Miller versus Brass Rail Tavern, which is in the written materials, you know, basically says that if someone has a reasonable pretension of specialized knowledge, in this case, you know, Larry Ferletta, a DEA agent who's conducted thousands of interviews, can come into a courtroom and talk about interviews that he's conducted on behalf of a client. You know, my background, for instance, as a prosecutor and a parole board member, provides me with specialized knowledge in these particular instances. And obviously, in Pennsylvania, it's still the Fry test in terms of expert witness and expert materials generally accepted in the scientific community. But also, even for sentencing purposes, even if you're not qualified as an expert, you can come into a sentence and testify as to hearsay, essentially, but what you've learned about this defendant, what you know about this defendant, what you think would be best for this defendant. And the Supreme Court in Green versus Georgia said that that is certainly appropriate. But I believe that that testifying and preparing a report at the earliest stages of a case is the most beneficial thing that you can do for your client. But not only that, I think in some cases, and I think this is going to evolve over time, in some cases it's going to fall below the standard of effective assistance of counsel if you don't do this. This is what the future is for lawyers in terms of advocacy on behalf of their client. Certainly, being a great trial lawyer is important in the negotiation process, because you can say, I'll go to trial and win this case. But the failure to negotiate, the failure to be involved in that process and be prepared for it, I think will have dire consequences for your client and possibly consequences for your own practice. With that, I'm going to turn it over to Larry to talk about risk assessment and other aspects of sentence advocacy.
Okay, Attorney John Masalero, he's probably no stranger to any of you in Allegheny County. He's been around 35 years or so now. Yeah, and John and I actually met in court many times. I've seen him, you know, working in Allegheny County. And then most recently, John and I were working in a classroom setting like this, and we have a case that we're actually working together now. And one of the things is that this little case might bring to your attention how this thing can work together. John is her legal counsel. She had two charges for DUI, one in Mercer County and one in Allegheny County. But we both recognized that this person had severe substance issues. Wow, she's probably been an active addict for well over 10 or 12 years.
And not only these two cases, there were two other cases that I got her off relatively easy at the magistrate's level. And since those cases, these other two cases evolved, one in which she was very reckless on a highway hitting a guardrail, and another one in which she actually overturned her Jeep. So some of my questions on this is, how good of a job do you do when you get people off so easy when they really got deeper issues like substance abuse and could end up killing themselves or killing someone else? And that's when I got involved with Angela.
And again, that goes back to what does a good lawyer do in a situation like that? Now, we've had some of these things come up, and I can tell you this, now this case is far from over, but as we speak, she is in in-house rehabilitation right now, And my understanding is from her father that she's working with Dr. Neil Capretta at Gateway, and she's due to be injected on Tuesday of this coming week. Now, John and I will take that, and I'm basically helping as treatment counsel on the treatment issues, and we talked about that this morning, and John already knows that because we're working with him. But John is going to press for every Sixth Amendment legal issue that he can as a way of upping the stakes on our negotiation. But at the same time now that she's in in-house rehabilitation, we have some time. We might be able to trade for mandatory sentencing. More importantly, those two criminal cases probably led her to us, which led her to the doctor, which led her to be injected. And we don't know, of course, how it's going to end up, but she'll probably be totally abstinent for the first time probably in years. And then when John can take that and use that with all the other things he's got going with 30 years of excellent trial experience, that's going to allow us to have the legal issues driving the medical result, and the medical result driving the legal solution on the back end, and doing what a good lawyer would do. And because we're running short of time here, John was going to talk to you about probation without verdict, which is in our Drug Act, and you have that basically, and that is in Section 35 PS 780-117. And then we also have, right after that, and you've been given this book here, and we have disposition in lieu of trial or criminal prosecution, and that is 780, again, 35 PS 780-118. And the third thing that John will speak to you about before we get to our next presenter here will be Title 35 PS 780-116, which talks about a person who has been tested dirty while they're on probation. Has anybody ever had a case like that? Okay, he's going to show you how it may be illegal for them to incarcerate such a person. And that's something I don't think most prosecutors or defense attorneys go. So I'm looking over there at our clock, and I lassoed him into this because one of our speakers, Miles Carson, got ill, but John and I, and John forgot more in some of these issues, and John and I are going to put this together, and I will prepare our next speaker before we get to Mr. Lindsay at 1:20, and John's going to discuss those three areas with you. And we are very pleased to have John here to present for us, and thank you, John.
Oh, no problem. Again, I was sort of lassoed into this, so please excuse me for not being as well prepared maybe as I should be, but the issue with probation without verdict, it is very important as far as clients go. Probation without verdict pretty much ends up with the person ending up with a clean record once they complete all the obligations of the probation. Why that is so important is, one, for drug offenses, this is that anytime you have a drug offense on your record, I'm sure I don't have to explain to anyone, it closes a lot of doors to you down the line. A lot of my clients are youthful offenders, 22, 21, 18, 25, and to have that on the record for the rest of their lives is a long hardship down the road, including government money for education and other things that you're excluded from. So probation without verdict is a very powerful tool. It's reserved usually first-time offenders. I mean, I've had some judges that will overlook that aspect, and granted, if you could present a good enough case for it. But there's some issues that, that if you plead or nolo contendere or plead guilty to the charges, and they agree to place you on probation without verdict, you're placed on a period of probation for a specific time. As long as you don't violate, commit another crime at the end of the probation, your charges will be expunged. In Allegheny County, it's an automatic expungement. There's some limitations that are listed in the book, but the one that strikes out at me most is that a person who has been placed on accelerated rehabilitative disposition. So if you have someone that has been placed in the ARD program, technically they're not really eligible for probation without verdict. So that's one of the stumbling blocks. If they've have any previous offenses, convicted of a misdemeanor or felony, they're not eligible. But as I say, in Allegheny County, and I'm speaking of that because I've been in other counties and every system's different, that there's such an overload, and there's some judges there that will consider the age of the victim, I'm sorry, the age of the defendant, and his experience and so on. And I've even had cases where people have been growing marijuana, felonies, that have been given probation without verdict, and that keeps it off their record, and that's very, very important. The other thing that he wanted me to talk about is disposition in lieu of trial or even a plea. And as it states here, if a person charged with a nonviolent crime claims to be drug dependent or a drug abuser, and prior to trial he requests appropriate treatment, included and not limited to admission or commitment under the Mental Health and Mental Retardation Act. In lieu of criminal prosecution, a physician experienced or trained in the field of drug dependency or drug abuse shall be appointed by the court to examine, if necessary, and to review the accused record and advise the government attorney. Now, this is pretty much up to the government's attorney if he wants to accept this, if he wants to do this in lieu of prosecution. If he does, they can hold the criminal charge in abeyance for a period of time not to exceed the maximum penalty that would be under the law. And you can only do this, again, you can only do this once for people, but it's another option for people that are first-time offenders and have a drug problem that may be able to get around it and not end up with a drug record. A lot of young kids don't realize that record stays with you the rest of your life. A lot of times, like, oh, can I have this expunged? Can I, I'll get calls. Were you convicted? Yes. You pled guilty? Yes. Well, then you can't expunge it, Probation without verdict provides that alternative for you, okay? And that's really a powerful tool. The other thing that he wanted me to talk about is that, just as he said, a lot of times people are on probation and they come up dirty. According to the Act here, they recognize that a rehabilitation program is not a light on, light off switch. It takes time, and people will have relapses. And it's important to notice that, especially as we were discussing about the overcrowding of prisons, the prisons for profit now, where we sort of got to send people to jail to make money. It's important for us to try to keep people out of jail and to try to have them to be rehabilitated. The reason I am trying to get more involved with Angelo's program is because over the years I've seen a number of cases where you do the best you can. I mean, that's our obligation. You're supposed to do the best you can for attorneys. I just talked to one kid, he's 26 years old, and he's still sort of stumbling through the drug scene, but he told me, he says, well, you've been such a good attorney, and I've had this kid 5, 6 times, and every time we've been able to pretty much work it through without him really getting cracked over the head. I never realized how serious this could be, and, that's maybe my fault. Maybe I didn't explain it enough, the kind of consequences that he could face. But all of us are out there trying to do the best we can for our people. This case that Angelo and I are involved in right now, I have some real serious doubts about it. I mean, this girl, like I say, there were 2 cases before this that I actually got settled at the magistrate's level. And, she pretty much got out of it dancing through the streets. The next time she calls me, it's where the state trooper had to pull her over because several 911 calls about her being weaving in traffic and finally hitting the guardrail, what the state police had seen her do. And then the next call was not even a month and a half later when she finally overturned her Jeep and there was a passenger in it. So, I mean, my ethics, just my own thing is, it's not about just take the money and get this girl the best you can. It's also maybe trying to prevent her from killing herself or killing someone else. And I think that's some of the things that, Angelo and I are trying to work on at this point. And hopefully it works out for her, because rather than her avoid a jail sentence or license loss or anything like that could come from this, she might be able to turn her whole life around. And to me, that's probably one of our things that we should be looking more into, especially in drug cases. That's about it. All right.
to introduce Dr. Jackie Respers, who will talk to you a couple minutes about our community effort, and then she will introduce our last speaker, who really needs no introduction. But Doctor, thank you for coming down here.
Good afternoon. Just glad to be here. I just want to talk to you a little bit about what we're doing in Newcastle as in our Substance Abuse Coalition. I am the president of that coalition, and I'm sure Angelo has told you previously about the ELM connection, the educational, legal, and medical connection that we are working toward. I am a retired educator, as he said. I was the principal of Newcastle High School for 16 years. I was also a professor at Youngstown State University and Slippery Rock, and I've retired from all of that. So yes, there is joy to life. You can retire. And I used to tell people when I see them that were retired, I say, you have to etch that smile off your face. And yes, you do, because everybody gets up happy when they're retired. But what we've tried to do is to bring together these three fields, educational, legal, and medical professions together, and everybody using their talents and skills and gifts. And we all have certain skills and gifts that we have been blessed with by God. As a member of the educational community, I've worked with young people for over 40 years, not only in my school district, but also in my church. And I have found that the problems that we face in Newcastle, PA, are the same problems that are being faced across the nation. And it is effectively and ineffectively affecting our nation. It is a tough call when you look out at young kids, young children whose parents were addicted, and because of their addictions, you find them having certain developmental problems and developmental attitudes, and not actually even recognizing authority or what they should and should not be doing in our schools today. And so everyone here, everybody here under the sound of my voice, has been affected in some way by addiction. Whether that addiction is in our families or in our coworkers or in our friendships, it may be in the cost of just alarming your home because you're afraid that somebody might break in. It may be in the cost of the taxes that you pay or the street that you won't drive down because we know that they are, quote, bad areas. And so these addictions that we are speaking about, whether they be prescribed or non-prescribed drugs, over-the-counter, or something that just somebody came up with to get high, these are the things that are affecting us. And so what we are trying to do is proactively affect the community. In other words, to put together a program that will teach young people. And sometimes the teacher is the one who spends the most time with the children. And their words then might mean the most. You never know, because we don't know what children are coming from, the homes, the backgrounds that young folks are coming from. And because their parents may be doing some things that they shouldn't do, they have no true direction. So the school then becomes their source of education. The question has been asked, what I could do as an individual? How can my efforts positively affect then this situation? Why shouldn't I just sit back and let the government do its job? Well, then it begs to be asked, if not me, then who? If not now, then when? I'm reminded of the words of the late President John F. Kennedy when he said, ask not what your country can do for you, but ask what you can do for your country. And we could take that into the same realm. I don't know what all the country can do. I don't know what the nation can do. But I know as a professional educator that I can do something to affect these young people, these middle-aged people, even these senior citizens that are addicted to various drugs. And so with that in mind, ELM looks to the efforts of the educational, legal, and medical professions to coordinate our efforts, to increase our knowledge base, to show young people what it is that they are facing in this world. Historically, the schoolhouse and the church house have been the foundations of our society. By the innovative thinking of Attorney Angelo Paper, the ELM team was able to present that concept on an educational site with a spiritual background. Our first summit, which was held at Kennedy Catholic High School in Hermitage, PA, we talked to grades 7 through 12. That included the administration, the faculty, and the students, and the public. And at this summit, we presented information which included social perceptions of addictions, because so many people take it so lightly. They really don't see what has happened in our country. They take it very lightly. They sit back, and if I don't see it, I don't know it. The medical, psychological, and legal components were also discussed, as well as the ramifications. And we also were given many words of encouragement and inspiration by one such speaker was former Steeler Robin Cole. And the young people played an interactive role in this, so that it's not just teach by teaching, but teach by learning and by doing, by being an active part of that program. I believe it was a great success. I'm not sure if he showed you the video of the conference or even some pointers from the summit, but it was a great success. The young people asked us to come back. And that's what we need to do. Go as many places, do as many things as we need to do in order to touch the lives of these young people, because actually they are our next generation. And as I always would tell my teachers in my school when I was working, I told them that you never know who you have sitting in those chairs. You might have a doctor, you might have a lawyer, or you might have a Martin Luther King sitting in your classroom that you might affect. And if we can just touch the life of one person, I feel like that we have done a lot. As Martin Luther King had said at his funeral, then my living will not be in vain. Our next speaker is Alexander Lindsay, Jr. He is a 1971 graduate of the University of Pittsburgh School of Law, where he was an associate editor of the University of Pittsburgh Law Review. He was the first full-time assistant district attorney in the history of Butler County. He also was appointed as Assistant United States Attorney for the Western District of Pennsylvania, a position he held until July 1980. He left the United States Attorney's Office and entered private practice of the law and has remained in that practice since that time. Most of his experience as a private attorney has been in the field of civil and criminal litigation in both federal and state courts. He also is married to his wife Patricia for 45 years. They have 6 children, and 17 grandchildren. And at this time, I would like to introduce to some and present to others Mr. Alexander Lindsay, Jr. Thank you.
Good afternoon, ladies and gentlemen. I am not familiar with what you've had in the other part of your course. I am uncertain what I have to say has to do with what you've had previously, but for the next 2 hours, it's my hope that I can entertain you. In saying that, there's an old saying, my job is to speak, and your job is to listen. I hope you don't finish up first. And I always like to start. Has anybody heard my 1-hour presentation on the 10 Commandments of the Practice of Law? Have you heard it before? You have. So I have a riddle that I always ask before. I like riddles, but riddles are only fun if you know the answer, if everybody knows the answer. So here's the riddle. Who can tell me, or excuse me, who can sing for me the most popular song in the history of the English language? It's been sung every day, thousands of times for well over 100 years. Who can sing it for me? Come on, you know this. Everybody knows this. Yes?
I know it, but I can't sing.
Do the best you can.
Happy birthday to you.
That is it. The most popular song in the history of the world, composed by the Hill sisters, Mildred and Patty Hill, 2 unmarried school teachers from Kentucky. In 1893, they wrote a book called Song Stories for the Kindergarten. The book was a flop. It didn't sell. Several years later, they changed the words to one song. The new words to the song were Happy Birthday to You. And the song was a smash. The book was a smash. The ladies became very wealthy. Indeed, to this day, there is still litigation over the royalties to that song. For example, that's why when you go into Applebee's or one of these restaurants, they have one of these goofy songs they sing for Happy Birthday. They can't sing Happy Birthday to You because they'd have to pay royalties. Now, the second part. Who can sing the original words of the song? Remember, same melody, different words. Come on, you all know this. Nobody? Too late in the day? Nobody wants to try? Good morning to you, good morning to you, good morning, dear teacher, good morning to you. Everybody familiar with that song? You all knew it, didn't you? The point of this riddle is to let you people know this. In the next hour, I'm going to talk what I have devised, the 10 Commandments of the practice of law. And in saying that, everything that I tell you, you already know. And so the question is why should you listen to this particular presentation? First of all, you must be saying, why should we listen to you, of all people? And the second issue is, if you have such a low estimation of what you're going to give us, why should we listen? First question first, why should we listen to you? Oh, there's a reason, my friends. I think it's pretty well documented that there's no lawyer in the history of Western Pennsylvania who has made more bonehead mistakes, made more bad decisions than any other lawyer. So, boys and girls, listen and learn. 2, do I have low expectations? Oh, no. In the next hour, I hope to give you certain information which will change your life forever. What I'm talking about is discipline. In order to be a good lawyer, particularly the kind of lawyer that I am, which is a trial lawyer, you must have 2 things. First of all, you must have passion, and you must have discipline. And the 2 of them work together, but they're actually against each other. So what I like to say is we have the thermocoupler theory of the practice of law. Does anybody know what a thermocoupler is? I thought not. A thermocoupler are 2 metals which are bonded together, and they expand and contract at different rates. The tension that's created generates a tiny bit of electricity which can run a thermostat for your house so you don't have to have electricity in it. But it's the tension between the 2. To be a great lawyer, you have to have passion. You couldn't put up with it. But passion without discipline is a cacophony. It's just a wild song. Discipline without passion is stultifying. So it's the 2 of them together that are important. Now, when we talk about the 10 Commandments, there are 10 Commandments, the biblical 10 Commandments, which are rules of life. We think of them as things which inhibit us from doing whatever we want, but actually they're kind of an owner's manual as to how to get through this without getting burned. Do we all follow the 10 Commandments? No. Should we? Yes. But we violate them in many, many ways, many, many times. With these 10 Commandments that I'm going to give you, do I always follow them? No. But I wish I did, because if I did, I'd be much better off. So, what are they? Rule number 1. I call it the rule of Sitting Bull. Sitting Bull was the great Sioux chief that, along with Crazy Horse, defeated Custer at Little Bighorn. But what he was most known for later in life was being part of Buffalo Bill's Wild West show. Buffalo Bill brought him in and he entertained people as the great Sioux chief. Everybody thought Sitting Bull could speak fluent English. He could not. He only knew 2 words. He only knew 2 words. But these 2 words he found could help him engage in any conversation with any white man. The 2 words were, you bet. No matter what was said to him, he'd just say, you bet. They could, nice day, Chief, you bet. How have you been? You bet. What does that have to do with the practice of law? Rule number 1 is this, is understand that everything you do as a lawyer may be scrutinized at a later date. And no matter what you do, you need to have it in your own mind that if you're asked under oath whether you did what you did, you could say, you bet. Did you serve those subpoenas at 10 o'clock on a Saturday night? You bet. Did you tell that witness that you would see to it that he would be prosecuted for perjury if he didn't testify as to this matter? Oh, you bet. So get it into your mind that whatever you do may be scrutinized at a later date, and you need to be able to say forthrightly, you bet. Rule number 2. It's what I call the rule of Ulysses Grant. Ulysses Grant is the father of all military doctrine in the United States. You may call into question his ability, but I'll rely on a guy by the name of Robert E. Lee, who wrote after the Civil War that Ulysses Grant was the greatest military genius in the history of the world. And as Lee put it, trust me, I've made quite a study of it. Grant, at the beginning of the Civil War, had a philosophy of being aggressive. His theory was if you have two armies which are untrained, if you take time to train your army, your opponent is merely doing the same thing. And when you have two untrained armies, it is generally the aggressive army that will carry the day. And so that's what he did at the beginning of the war. His untrained armies won victory after victory, and he eventually became the commander of all of the armies. He was the first lieutenant general that the United States had since George Washington. With regard to how this applies to the practice of law, you should be decisive and take action. All of us procrastinate. Procrastinate not because we're lazy, but we procrastinate because we can't make up our mind what we want to do. And what we are afraid of, are we not, is that we will make a decision which will expose us as not being, as Angela would say, a good lawyer. In other words, someone will take our briefs, someone will take our pleadings and take them apart, and we won't be a good lawyer. I like to say that I'm not so much concerned at this stage of my practice whether I'm a good lawyer, but rather, am I a good enough lawyer? In other words, get it filed. It may look bad. I've got a clue for you. If you file a complaint, a civil complaint, for example, no matter what you put in it, they're going to file preliminary objections or Rule 12b-6 motions on the federal side. So file it. Get it done. And if you look bad, you're going to look bad to the other party no matter what you did. Be decisive, take action. I used to say in my office, you could always tell my files because they had black strips on them. And the black strips where my chair ran over them and left that wheel, left that mark on the files as they laid on the floor. Don't do that. Don't do that. Take action. I often say that files sometimes, or cases, when we leave them sit, are like that half-eaten container of cottage cheese which is in the back of your refrigerator, and you know you want to take it out and open it up and see how it is, but maybe you don't either. So the important thing is move cases, take action. Another reason you should take action, I found in my 40 years of the practice of law, if you don't take actions for a client, sometimes the clients solve their problems themselves. They don't need you, which is not a good thing. Rule number 3, it's the rule of Thomas Edison. Thomas Edison was a friend of Alexander Graham Bell. Alexander Graham Bell invented the telephone, and he also came up with what he thought would be the perfect universal salutation for the telephone, and that was ahoy. So when you picked up the phone, you would say ahoy. And he talked to his friend, Thomas Edison, and told him this, and Edison said, no, that will not do. Let me think on this. And Edison came back and he invented a word that would be a universal salutation, and that word is hello. What's the point of this with the practice of law? Folks, you got to answer the telephone. You got to actually talk to clients, and you have to return their calls. And that's not easy, because often they're asking you questions that you can't answer. All I can tell you is this. is remember this, that when a client calls you, the sweetest sound in the world is the sound of your voice. They need to talk to you. With that in mind, I heard something once. It was about 10 in the morning, and I remember where I was. I was on I-79 coming back from the airport, and I listened to NPR, which is not my custom. But they had someone on talking about a study that had been done. What they were studying, or what this documentary was about folks who had been subject to malpractice on the part of a physician, serious malpractice, grievous damages, but refused to sue their doctor. And so the idea, what did these doctors have in common that they were not sued even though they had committed this malpractice? Was it because they were specialists or not specialists, country doctors, city doctors, old doctors, young doctors? What was it? None of those. It was their tone of voice. It was their tone of voice. And I thought to myself as I was driving down I-79, better work on my tone of voice on the phone. And so when I go to pick up the phone, I work on my tone of voice because it makes a difference. Also, I think, understand is we have cell phones now. The glorious part of a cell phone is you can return the call and then explain to your client that you really shouldn't engage in attorney-client conversations on it, so you'll call them back later if that's your want. Rule number 4, and this is one of my favorite rules. It's called the Harvey Rule, or the Rule of Elwood P. Dowd. Has anybody ever seen the movie Harvey with James Stewart, or the play? It's a great movie. See the movie. But what it's about, Elwood P. Dowd is this bachelor man who likes to invite people to bars to drink martinis, but he has a companion that no one can see. It's a 6-foot rabbit, a puka, as it were, that nobody else can see. In the course of the play or the movie, Elwood P. Dowd is committed to an insane asylum because they think he's crazy. As it turns out, he's the only sane one around. The puka is real. And what occurs at the end is that everything gets straightened away, and the psychiatrist, who now becomes aware of the puka and engages in conversations with the puka, says this to Elwood P. Dowd. Mr. Dowd, why are you so nice? He says, well, I learned a long time ago, my mother said to me, she said to me, Elwood, that's what she always called me, was Elwood. If you're going to be successful in this world, you have to be very, very smart, or very, very pleasant. I tried smart, now I'm pleasant. And what I like to tell people, that in the line of work that I do, which is basically at a courtroom almost every day, if you're going to be successful, you have to be oh so clever, or oh so pleasant. I tried clever, now I'm pleasant. And I think it's very, very important in all your dealings to be very, very pleasant. In my geographical area, I know where Curtis was, Butler County. I don't think I like to bill myself as the smartest lawyer or the most experienced lawyer, whatever, just the most pleasant lawyer. And I think it's very important. If you are pleasant, you will find that over the years you build up what I call a reservoir of goodwill, which is very, very important because, you know, you're going to make mistakes. I once made a New Year's resolution that I was going to quit making mistakes. At about 2:30 p.m. on January 2nd, I made my first major mistake that year. You always make mistakes, and you need people to help. And if you're a first-class prick to everybody you deal with, you're going to find that it's very difficult to negotiate the choppy waters of the practice of law. It's interesting. I once had a situation where I needed to amend a complaint. And you have a certain time you can do that as a matter of course, and that time had run. So I needed to go to the court, and I needed to get the other parties to agree. There were 3 lawyers who were opposing me to permit me to amend the complaint. And I figured, how am I going to approach these 3 lawyers without getting burned? And then I took a look at the names that were on the pleading, and I realized with these 3 lawyers over the years, each one of them, I had had the opportunity, and I had declined to be pissy with them. And consequently, when I called them up, each one of them said, sure, fine, there was no problem. But you really can't function in this world without cooperation from lawyers on the other side. Along that line, I think it's interesting to read correspondence. Sometimes you get letters from lawyers that they're 2-3 pages long, filled with vitriol. They're very clever, cute, smart, scathing, and so forth. And the tendency is when you get one of these letters is to respond in kind. Don't. I always suggest this. Any piece of correspondence that goes out of my office, if it's at all combative or whatever, I hold it for a day and I look at it the next day. And the idea is when you look at one of these pieces of correspondence, what you want to do is look at it and imagine it being read to a jury at some point later on in a particular piece of litigation. All of the things that you thought were so clever when you put them in the letter. Don't do it. I've generally found if you get one of these vitriolic, nasty, smart, cute, smart alecky letters, if you really want to stick it to someone, you don't respond in kind. But you state in the letter you're not going to respond in kind. And you do it, you'll get the letter, you answer the letter in a very matter-of-fact way as if nothing was said. And maybe the last sentence in the letter is, the tone and tenor of your letter is noted, I will not engage. And that is really humiliating someone when they've worked so hard and you just say, ain't gonna go there. So, at any event, the reservoir of goodwill is very, very important. Rule number 5. It's the rule of Greyfriars Bobby. Anybody know who Greyfriars Bobby is? Nobody knows? Nobody knows. All right. He was a Scottish terrier, a Skye Terrier, excuse me, in Edinburgh, Scotland. Greyfriars Bobby was this little dog that was owned by a watchman by the name of John Gray. And every day this little dog would follow John Gray around, and they would go to a particular tavern and they would get food at noon. Scraps of food to be given to the dog, and then he would go on his rounds. John Gray died. And when they buried him in this churchyard, the dog laid on the grave, and everybody left. The next day, the dog was still on the grave, and the dog got up at noon, went to the bar, got the food, and went back and laid on the grave. The dog laid on the grave for years. It went on and on. He became a tourist attraction. People would come to Edinburgh, where's the dog? And they would look at this, dog get up at noon, go get the food, and come back and lay on his master's grave. If you go to that churchyard today, there's a monument to this dog, Greyfriars Bobby. Well, what's the point of this in the practice of law? I always like to tell my clients that America is a lovely place because you can buy loyalty. You can hire a lawyer or get a dog. And the problem I have found is lawyers don't seem to get that. They don't understand how important it is to be loyal to a client. I do a lot of criminal practice, and I'm always surprised when lawyers tell me how they brag about that their client said they were innocent, but they convinced the client to plead guilty. And I'm like, what? It's their case. It's their life. All you do is you facilitate what's happening. But I think so many lawyers like to believe in their own hubris, I guess, or arrogance, that they're going to make the decisions. I have a rule in our office, if we get to the point where we can't say good things about a client or we don't like a client, we get rid of the client. And we just have to say we have to part company. Because once you get to the point that you don't get along with the client or you don't see eye to eye, it's a very unhappy situation. Are you guys with me so far? Are we okay? Got these rules? All right, we're down to number 6. We're rocking and rolling. We may finish before Angela wanted. Rule number 6 is the rule of L. Cortland Lee, Who is L. Cortland Lee? Why, he's my cousin. And he lives in Washington, D.C. And the reason that I bring him up is I had they were cousins, they were brothers. The thing that they had in common was that they raised bees. They had nothing else in common. The older brother died in the last year. His name was Ed. He was a fastidious little man. And he would give you honey for Christmas, and it'd be in a little jar like this with a little ribbon on it. His younger brother, Court, who was a year younger, was a huge, boisterous man. And you go down to his place and said, "You want some honey? I got some honey for you." And he'd give you 10 mason jars, and the whole garage was filled with honey. But Court Lee had the idea that when it comes to bees, you got to work them. Bees are naturally lazy, so you got to keep taking the honey so that they make more and more honey, but you got to work them. And ladies and gentlemen, boys and girls, it's my opinion that if you want to have a successful relationship with your clients, work them. Work them. Keep the ball in their court. Get them to do the work. Get them to go through the papers. And always have tasks for them to do. We get the idea that when clients call us, they nag us, so to speak, "Have you got this done? Have you got that done?" And it's somewhat irritating to us. And we think that it's similar with the client. When you give them things to do, they don't like to be bothered. No, no, no. They love to be bothered. They love a lawyer who calls them every day and say, "Where the hell's that information you promised me?" "Hey, if you don't care about the case, I don't care about the case." "No, Al, we care about the case." So one of the things I think that will help you have a good relationship with your clients is to work them. Number 7, it's the rule of Nancy Reagan. And of course, we all know what the rule is, right? What is it? Someone said it. Who said it? Just say no. We get the idea that clients want us to do things that does not comport with our sense of the way things should be done, or does not comport with our sense of ethics or legality, or it's just bad for whatever reason, and that we somehow have to do it, or the client will do bad things to us. Au contraire, my frère. Don't do things that you don't want to do. The question is how do you deal with a client who wants you to do something that's improper, which is not that improper? I got a solution that's always been useful for me. I had a client once, in my early years of practice, that wanted me to file a deed where they stated on the deed that there wasn't any money paid, so they wouldn't have to pay the transfer taxes. I said, "Well, there was money paid, and this is being filed under oath." And the guy says, "Well, come on, who's to be the wiser? You're not going to tell anybody." And I said, "All right, I'll file it, but in order to file that, I need $1 million up front." And he said, $1 million? What are you talking about? I said, "My friend, if I'm going to spend eternity in hell, I sure as hell going to live good now." And he said, "Okay." So we filed an appropriate one. But if you have morals, that's something that you have to consider. There's a corollary to this rule, and the rule is this. This came down, I'm a third-generation lawyer. This came down from my grandfather to my father about the practice of law, and that is this: never put yourself as a lawyer in a position where you can't tell a client to go to hell. In other words, where some client has you for some reason in a position where you have to do what they want you to do no matter what. That you have a client that your whole practice is based on, a client who for some reason has something that can put you in that position. One of the happy parts of practice, I should tell you, is the ceremonial firing of a client you don't care for or wants you to do something. This can be a very pleasurable thing. And one of the things you'll find is a lot of clients, when they find out that you're letting them go as opposed to them letting you go, react in a way, "Well, wait, let's calm down here." But there's nothing wrong with it. You just say, "I guess we don't see eye to eye anymore. It's not working out, is it? We've reached a fork in the road." All of these things that you can say. But it's really, I have young lawyers that have worked with me over the years. What are we going to do with this client? The idea is fire them. And generally, the client decides that that's not what they had in mind when they started off on the road that was contrary to what you thought you should be doing. Rule number 8 is the rule of Joe DiMaggio. Joe DiMaggio, I think, does everybody know who Joe DiMaggio was? I hope. I don't know anymore. It's what people know. Joe DiMaggio was the great center fielder for the New York Yankees, a Yankee Clipper. And the reason I bring Joe DiMaggio up was this. Late in his career, he was quite injury prone. And there was a game, and I believe it was in 1949. Yankees were making a run for the pennant. No, it wasn't 1949. It was a later year, I think 50 or 51. The Yankees had clinched the pennant. They were playing in a meaningless game. It was in the ninth inning. There was a long fly out to center field in Yankee Stadium, the top of the ninth, and DiMaggio begins to stride out in that familiar lope of his to the center field wall, and he crashed into the wall. Caught the ball. There was a gasp, an audible gasp in Yankee Stadium. And then DiMaggio got up, and he ran to the dugout. The game was over. He was asked by a reporter later, why would you do that? Why would you risk your health on a play that had no meaning? And his response was this: there are people in that stadium today that never saw me play before and would never see me play again. And their whole idea of what I was as a ball player would be what they saw on that day. So what's that have to do with the practice of law? Well, boys and girls, we are on stage every single day. And what people think of us is going to be generally determined by what they see on a given day. You'll find the great lawyers, people will talk about them. They'll say, I saw him at a preliminary hearing. He was really something. Or I saw him do a zoning hearing board hearing back 10 years ago, and I'll never forget the cross-examination. We are judged constantly on what we do that day. And one of the things we as lawyers don't get is that many people, when they come to see us, we're the first lawyer they've ever seen or consulted with. And their whole idea of the legal profession is based on our conversation with them at that particular day. You know something that's interesting? I think that so many of our judges don't get that at all. We have some of these tyrants on the bench doing whatever they're doing, and without any concept of how that affects people, because there are many people that have never been in a courtroom before or after, jurors, witnesses, or so forth. And their whole concept of the American judicial system is based on how that goofball was acting on that particular morning. So please remember that when you're in court. You're always performing. You're always being judged. Rule number 9 is the rule of Woody Allen. Woody Allen is purported to have stated that 90% of success is just showing up. And folks, there are many, many times in the practice of law, particularly if you do what I do, which is litigation, you don't want to show up. I mean, things are not going to go well. Your client has done something in the interim. There was something you were supposed to file, you didn't file. The judge is upset with you. You get back through the grapevine. You don't want to show up. And what I'm here to tell you is just show up. Be there. And remember this. I'm going to give you something now which is worth millions. Please listen to me. Remember this. Silence is golden. In other words, if you get yourself into a situation, so often I've found when I'm in a position of disadvantage and the judge calls us into chambers, I don't talk. Lawyers are funny. If there's a silence, your opponent will fill the air. You can't have it silent. They're going to state their position. And they will continue to press and press and press with their position until you stop them. But you're not going to stop them, are you? You're going to sit there and gaze passively out the window as this lawyer continues to expand and expand with what they want. And eventually they go too far. And the judge says, that's not right. They say they're going to do something. The judge says, you can't do that. You haven't pleaded that. I don't need to plead it. Yes, you do need to plead it. And pretty soon the judge is into a full-blown argument with your opponent. Eventually the judge realizes that there's somebody else in the room and turns to you and says, what's your position? My response is always the same. Oh, I agree with you, Judge. And I've won all of those arguments. Another thing that will help you in that endeavor, here's something else I'm going to tell you that's worth me, is remember the rule of Dale Carnegie. Anybody familiar with the books of Dale Carnegie, How to Win Friends and Influence People? It's really a wonderful book. But one of the ways to make people instantly like you is to talk about what the other person's interested in. When you go into judges' chambers, judges are funny. They fill it with their stuff, their pictures of their boats, their pictures of their golf outings, whatever. And so what I've always found is you sit down, but before they could talk about the case, you talk about the pictures. And you spend time doing that. And eventually you get to the case, but the judge is on your side. I got to tell you something. It's a crazy story, but it's true. I had a case which I had a hopeless situation. My client was behind on a mortgage. It's a small matter of $16 million. We needed 60 days. There was no legal basis for me to request a 60-day extension to begin the forfeiture proceedings, but the judge had a wee bit of discretion that he could exercise. So I'm in courtroom, I just showed up, I don't know what I'm going to tell this judge. So I'm seated there, and the clerk comes out and said, the judge would like to see you in chambers. So I go through my routine. I go into chambers, I scope the chambers. Nothing! No pictures on the wall, nothing on his desk. And then I saw my in. The judge had a bow tie. Most people don't wear bow ties anymore. I happen to be one of those select few who can actually tie a bow tie. And periodically I wear bow ties. And so as we sat down, I looked at the judge and I said, I can't help but notice you wear a bow tie, Judge. Where do you get them? And he started to talk to me about the bow ties. And he and I then went into this long discussion about where you get bow ties and so forth. The guy sitting there, this went on for 15 minutes. And then I turned to him, my opponent, and I said, you know what the difference is between tying a necktie and a bow tie? He goes, no, I don't know the difference between tying a necktie and a bow tie. And I said, well, the difference is this. With a necktie, if it's not right, you untie it and start again. But with a bow tie, once you have your bow, you never give up on your bow. And the judge said, he's right, you never give up on your bow. And then he looked at him and said, why don't we give him the 60 days? and so I got my 60 days. So, in any event, that's the rule of Rudy Allen. Now we're to the last rule. And that is the rule of Natalie Wood. Natasha Gerdine. Natalie Wood. What is it about Natalie Wood? I don't know if you people remember much about Natalie Wood. I thought she happened to be one of the most beautiful creatures that the good Lord ever put on earth. I think of that scene in Splendor in the Grass at the end where she approaches when she comes out to the farm and Warren Beatty's there and she's got the white collar on. I mean, oh my, my, my. She was very, very beautiful. But she didn't think so. You see, she had a problem. When she was 9 years old, she was in a movie and she broke her wrist, her left wrist, and it wasn't properly set and it was deformed. And so she had this left wrist that bothered her so much. If you go online, you'll see that every picture has this huge bracelet on her left wrist because she's trying to hide this bone deformity. And so no matter how beautiful she thought she was, or we thought she was, she didn't think so. And there is the other thing about Natalie Wood is how she died. She had a very high blood alcohol at the time she was fished out of the Pacific Ocean near Catalina Island. She had been drinking with her husband, Robert Wagner, and Christopher Walken, and had somehow found her way into the water and had drowned. The sheriff's deputy who fished her out, they brought her in and they laid her on this table, and her eyes were open. She was, of course, dead. And he said, my goodness gracious, how beautiful she was. but she had too much alcohol in her system. And so she's significant to me in this regard for two reasons. Number one, she was beautiful but didn't think so. And number two, the manner of her death. She abused that beautiful body by putting too much alcohol under the circumstances. So what's that have to do with us? First of all, none of us have a perfect body. Most of us wish that we had a different body. We look different. I'm here to tell you something. You can write this down. This is probably the only body you're going to get. And no matter how much you dislike your body, you may think you're a great lawyer. You may think you have a brilliant mind. But I understand that if your body's dead, your mind ain't worth a crap. So the important thing is you've got to take care of it. You've got to control what goes into it and accept it for what it is. I like to tell something I always think is interesting. I was born with a birth defect. I have what's called a wing scapula. A wing scapula is a malformation of a shoulder, a scapula. And my right shoulder is very different from my left shoulder. I have atrophy of the muscles on this side. My back is built up. And all of my life I spent trying to get suits fitted so that I look normal, even with this wing scapula. I thought it was interesting. I gave up on that when my tailor that I buy these suits from is a guy in New Kensington by the name of Guido Bartolesi. And I ran into another lawyer who bought suits from Guido Bartolesi. And he told me the story. He went in to be fitted. And Guido, when he comes in, you get on the suit, whether he has it made or whatever, and then he pins it and puts soap marks on it all over. And this lawyer was telling me that he went in to see Guido about his suit. And he had these alterations, and he said, "This is really something." And Guido said, "These? Nothing. Let me show you Mr. Lindsay's suit." And he pulled it out, and it had all been ripped up, and I realized that there was no tailor customer privilege. that my problem was out there. But I have this malformed body that I've grown up with, and you know, at this stage of my life, I wouldn't give it up. I mean, I can use it as a prop in a lecture, and so it has value. But all of us have issues with how we look or our bodies and so forth. But it's remarkable what they can do, and we have to take care of them. And that's the rule. Take care of your body and take care of what you put into your body, and also take care about your relationships because they're all significant. So here those are the 10 rules, and I hope you'll find that they're valuable. I gave you what was the first segment of what I was going to deliver, and now I'd like to move to the second. And this is something I've never done before. I don't know what it has to do with Angelo was doing, but I told Angelo this is what I was going to do, and now you'll be subjected to another hour. Hopefully it'll be unlike what you've heard before. And that's this. Did you ever wonder why you became a lawyer in the first place? Did you ever think to yourself, whatever led you to be a lawyer? Maybe you watched LA Law, maybe you watched Law and Order, maybe you were interested in making a lot of money, maybe you had ideal reasons for being a lawyer. But now you're at a stage in your career where you wonder, how did this happen to me? I'm in a situation which is highly stressful. I am in a business which is an unhappy business. You know, people don't go to lawyers because they're ready for a good time. People go to lawyers because they've been sued or they need to sue someone. They've been prosecuted criminally or they think someone else should be prosecuted. It's generally, there's adoptions, which are fun, I guess. But outside of that, there's just not much that's really that happy about being a lawyer. If you're in the practice of law, you generally get into the financial stresses and strains of trying to run a law practice. In my particular case, I find whether or not I think I'm a good lawyer depends on whether I made payroll on a particular pay cycle. If I have, I think I'm a good lawyer. If I haven't, I think, why have I done this for all these years? We are treated with contempt by many people in society. There's the lawyer jokes. You know, people think that it's funny when you're involved in some type of activity and people call you a liar because you're a lawyer, things of this nature. So it's a very frustrating way to make a living. I, for one, never intended to be a lawyer in the first place. I became a lawyer quite by accident. I'm a third-generation lawyer. It was always assumed that I would be a lawyer, but I didn't want to be. In 1968, when I graduated from college, I had received an ROTC commission, and I was to go into the service. I probably would have been an infantry platoon leader in Vietnam, but what occurred was I was a wrestler, and I seriously injured my knee, and the Army wouldn't take me for 2 years. My father, of course, said, "Why don't you go to law school?" I said, "Because I don't want to be a lawyer." And he says, "What the hell else are you going to do for 2 years?" And I wound up going to law school, and I wound up being a lawyer. And there are times which I feel very trapped. Very trapped. I feel like I'm a slave. You know, every day there's some schedule, some place you have to be, some judge you have to be in front of, some client you have to deal with, some brief that has to be done. And I wonder why I'm doing it. And when I get that way, I like to think about certain lawyers that have inspired me. And what I want to do today is just tell you about 3 or 4 of these lawyers and what they did and why they are an inspiration. The first one is William Francis Murphy, Frank Murphy. I became acquainted with him when I was in law school. In 1970, I took constitutional law at the University of Pittsburgh in the old law school at the Cathedral of Learning from Stanton Weddick, who was a young law professor. They now call him Judge Tony Weddick. He's probably the most prominent common pleas judge in the state of Pennsylvania. Professor Weddick, in the course of his constitutional law course, told us or gave us an anecdote, and this is what it was. He was on the Yale Law Review, and he was permitted to go along with other Yale law students to the Supreme Court, where they were able to interview a particular Supreme Court justice. The justice that he interviewed was Justice Hugo Black. And young Tony Weddick, law student Tony Weddick, at the height of impertinence, said this to Hugo Black, this prominent justice. "Justice Black, I have a question for you. How could you, author of so many wonderful civil rights opinions, one of the great liberal minds on the Supreme Court, how could you have, of all people, written the Korematsu decision?" The Korematsu decision was a decision by the United States Supreme Court which made legal the taking of citizens of Japanese ancestry and placing them in effect, concentration camps, whatever you wanted to call them, in various places in the West. How could you have done that? And his reply was to Tony Weddick, "Well, let's get one thing straight. The Korematsu decision was the worst decision that was ever handed down by the United States Supreme Court, and I have to live with the fact that I wrote it. But you've got to understand the way the country was at that time. In a very bizarre, weird way, by writing this decision, we felt it was our way on the Supreme Court of supporting the war effort. We went along with what the Defense Department wanted, and we supported the war effort. But they all didn't go along. One of them, or 2 of them, did not, and one of them was Justice Frank Murphy. Who was Justice Frank Murphy? Frank Murphy was the United States Attorney for the Eastern District of Michigan in the early 1920s. He became mayor of Detroit, and he ran for Congress, was defeated, and then he ran for judge and was elected, or went on the bench on what was called Recorder's Court in Detroit. Recorder's Court is criminal court. And while he was in that position, there was a very prominent case that came up. It was the case of Ocean Sweet. Ocean Sweet was a black physician who moved to Detroit. and had the unmitigated temerity to think that he could buy a house like anybody else. And so he bought a house in a white working man's neighborhood and thought that he could live there. Well, one night there was a riot of people that wanted to get Ocean Suite out of the area, and they rioted around his house. It was a mob. They threw stones through the windows, smashed the windows, and there were 9 black men in the house. And they had guns, and shots were fired from the second window. One of the mob was killed, and another was wounded. All 9 of these men were prosecuted for murder. No one in Detroit would have anything to do with this case. It was so controversial. They couldn't get a judge to try the case. The only judge who was willing to try the case was the youngest judge on the bench, Frank Murphy, and he agreed to try the case. The Sweet family was able to obtain the services of a prominent defense attorney by the name of Clarence Darrow to defend the Sweets, specifically Dr. Ocean Sweet. And Darrow made a deal with Dr. Sweet, and it was this: I will defend you on one condition, that we're not going to make it a case about who fired the shot, and you're not responsible for firing the shot. I will defend you only on the condition that the defense will be that you had every right to fire that shot because you were defending your home from a mob. And Sweet agreed. And Sweet eventually was acquitted, as were all of the 9. Interestingly enough, Clarence Darrow was once asked, did you ever get a fair trial any place? He said, one time. One time. And that was a defense of Ocean Sweet in Detroit. So what happened to Frank Murphy? Frank Murphy went on to become the governor of Michigan, the Attorney General of the United States, and a Supreme Court justice. And what I want to read to you very briefly is what he said in his dissent about the Korematsu case. The position of the majority opinion and the government is that we needed to isolate people of Japanese ancestry from the West Coast because it's necessary for defense. It's a defense measure. And this is what Murphy said. This exclusion of all persons of Japanese ancestry, both alien and non-alien, from the Pacific Coast on a plea of military necessity in the absence of martial law ought not to be approved. Such exclusion goes over the very brink of constitutional power and falls into the ugly abyss of racism. The judicial test of whether the government, on a plea of military necessity, can validly deprive an individual of any of his constitutional rights is whether the deprivation is reasonably related to a public danger that is so immediate, imminent, and impending as not to admit of delay and not to permit the intervention of ordinary constitutional process to alleviate the danger. And he went on to say that the government, the majority, they are claimed with regard to the Japanese, or persons of Japanese ancestry. These were not Japanese people. These were American citizens who had been born here. They are claimed to be given to, quote, emperor-worshipping ceremonies, end of quote, and to, quote, dual citizenship, end of quote. Japanese language schools and allegedly pro-Japanese organizations are cited as evidence of possible group disloyalty, together with facts as to certain persons being educated and residing at length in Japan. The main reasons relied upon those responsible for the forced evacuation, therefore, do not prove a reasonable relation between the group characteristics of Japanese Americans and the dangers of invasion, sabotage, and espionage. The reasons appear instead to be largely an accumulation of much of the misinformation, half-truths, and insinuations that for years have been directed against Japanese Americans by people with racial and economic prejudices, the same people who have been among the foremost advocates of the evacuation. I dissent, therefore, from this legalization of racism. Racial discrimination in any form and in any degree has no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but it is utterly revolting among a free people who have embraced the principles set forth in the Constitution of the United States. All residents of this nation are kin in some way by blood or culture to a foreign land. Yet they are primarily and necessarily a part of the new and distinct civilization of the United States. They must accordingly be treated at all times as the heirs of the American experiment and as entitled to all the rights and freedoms guaranteed by the Constitution. Another lawyer that I like to think about is William Henry Seward. We all know William Henry Seward as the Secretary of State in the Lincoln administration. Very interesting guy. At the beginning of the Lincoln administration, he and Salmon Chase got the idea that this backwoods lawyer from Illinois could not be president. He couldn't carry the load, so the two of them decided that they would form what was called the Albany Plan, and they would run the government, and Lincoln would be a figurehead. Chase never got it and continued to feel that way throughout the war. But Seward, on the other hand, very quickly learned what Lincoln was all about. He wrote his letter and said, the cabinet is made up of magnificent men, but the president is the best of us all. And they became the closest of friends, closest of allies. Apparently Lincoln, during his cabinet meetings, would come out with all of his various things, and Seward would lay on the sofa and just chuckle. He couldn't get enough of what Lincoln was doing. But we're now talking about a different time. He was the governor of New York in the late 1830s and early 1840s, and he became a senator of the United States. But after he became governor, he went into private practice and became, of all things, a patent lawyer. But he was probably the most prominent lawyer, without a question, in New York and maybe the United States. He lived in a town called Auburn, and an incident occurred in Auburn, New York. There was a 23-year-old African-American freeman by the name of William Freeman. Freeman had been prosecuted and sent to prison for 5 years for a crime that he did not commit. While in prison, he was beaten unmercifully. He lost his hearing. He became insane. When he was released from prison, he was involved in murdering a welfare farmer by the name of John Van Nest. He also killed Van Nest's pregnant wife, his child, and Mrs. Van Nest's mother. He was captured, confessed to the crime, had no remorse, laughed uncontrollably when confronted. As he was taken to prison, the citizens of Auburn, New York, thought there was only one thing to be done, and that's to lynch this man right then and there, but they got him to the prison. But then the question was, how do we try this man? Threats had been made by many people that if any lawyer would undertake to represent William Freeman, that lawyer would suffer severe repercussions. The judge, the court for Auburn, called all of the lawyers of the county together in the courtroom and asked, will anybody defend this man? And there was a death-like stillness pervaded the crowded room, and then Seward stood up and said, may it please the court, I shall remain counsel for the defendant until his death. And then he proceeded to do what was necessary to defend William Freeman. He was subjected to profound scorn from many of his political allies. It came out that the only person who really supported him was his wife. He managed to put on a vigorous defense for Mr. Freeman, He called 5 doctors who said how hopelessly insane this man was, and he was insane because of the brain injuries that he had received as a result of being wrongfully imprisoned. But the case went to trial, and it was a foregone conclusion that he would be convicted because of his race. Seward, in his closing argument, said this: "He is still your brother and mine. I am not the prisoner's lawyer. I am the lawyer for society, for mankind. Shocked beyond the power of expression at the scene I have witnessed here, trying a maniac as a malefactor. He begged the jury not to send him to death. He said, commit him to an asylum for the term of his natural life. There is not a white man or white woman who would not have been dismissed long since from the perils of such a prosecution." But it was a foregone conclusion, and Seward knew it, that the man would be convicted and sentenced to death. In closing, in ending his summation, he said this: "In due time, gentlemen of the jury, when I shall have paid the debt of nature, my remains will rest here in your midst with those of my kindred and neighbors. It is very possible they may be unhonored, neglected, spurned. But perhaps years hence, when the passion and excitement which now agitate this community shall have passed away, some wandering stranger, some lone exile, some Indian, some Negro may erect over them a humble stone, and thereon this epitaph: he was faithful." It's interesting. If you go on the internet, you can find grave sites. If you find William Henry Seward's gravestone, which is at the Fort Hill Cemetery in Auburn, there's an urn at the back, and it has these words: he was faithful. Another lawyer that I find interesting is Frederick Augustus Aiken. On May 9th, 1865, a trial began in Washington. It was a trial of the conspirators who allegedly killed Abraham Lincoln, and among them was Mary Surratt. She was charged with aiding, abetting, concealing, and harboring the other co-defendants in her boarding house in Washington, D.C. There were no lawyers willing to undertake her defense. The testimony against her was based on 2 witnesses, a Lewis Weichman and a John Lloyd. Their credibility was severely called into question by the lawyers, particularly one lawyer, who Mrs. Surratt managed to get her to defend her, and that was Frederick Aiken. Who was Aiken? Aiken was 32 years old. Aiken's an interesting character. He was somewhat sympathetic to the Confederate cause, but he joined the Union Army, and he had been wounded while fighting for the Union Army, and he was an officer in the Army. He left the Army in 1865, and he joined with John Clampett to set up a practice of law. He defended Mary Surratt. He was asked to defend her, and he did. He defended her vigorously, but it was unsuccessful, as we all know. Mary Surratt was convicted. The testimony of Lloyd and Weichman was believed, and she was convicted and she was hung. As a result of his defense of her, his practice was ruined because of the backlash of defending her. He was unsuccessful for the rest of his practice. He was asked to defend Jefferson Davis later on, but Davis was freed and he never had that opportunity. He died in 1878. Not that significant, and there's very little we know about him. But what he said in his closing argument in the Mary Surratt trial. It began with this, and this is what I've been taken with. I guess I can give you editorial comments. I like this. So this is what he said. Mr. President and gentlemen of the Commission, for the lawyer as well as the soldier, there is an equally pleasant duty, an equally imperative command. And that duty is to shelter from injustice and wrong the innocent, to protect the weak from oppression, and to rally at all times and on all occasions when necessity demands it to the special defense of those whom nature, custom, or circumstance may have placed in dependence upon our strength, honor, and cherished regard. That command emanates and reaches each class from the same authoritative and omnipotent source. It comes from a superior whose right to command none dare question and none dare disobey. In this command there is nothing of that lex talionis which nearly 2,000 years ago nailed to the cross its divine author. Therefore, all things whatsoever ye would do, therefore, all things whatsoever ye would that men should do to you, do you even unto them, for this is the law and the prophets. God has not only given us life, but he has filled the world with everything to make life desirable. And when we sit down to determine the taking away of that which we did not give, and which once, when once taken, we cannot restore, we consider a subject the most solemn and momentous within the range of human thought and human action. And then he went on at great length to give his summation in Mary Surratt's defense. As I indicated, he died somewhat obscure. He was buried in Oak Hill Cemetery in 1878 in an unmarked grave. His role in the Mary Surratt trial became quite prominent in a movie that came out in the last couple of years called Conspiracy, which was a Robert Redford movie. And in June of 2012, they located his grave, and they erected a monument on that grave. There was no monument before. And it says these simple words: Aiken, Frederick A., 1832, 1878. For the lawyer as well as the soldier, there was an equally pleasant duty, an equally imperative command. And that duty is to shelter from injustice and wrong the innocent, to protect the weak from oppression. John Adams. You notice I gave all the middle names? You know, Frederick, Augustus. So John Adams, I groped to find his middle name. Can anybody tell me what his middle name was? That was his son. You know. Nobody know? John Adams. He didn't have one. None of them had middle names. George Washington. Thomas Jefferson. Benjamin Franklin. It's not till we get to the 20th century that we get, you know, Dwight David Eisenhower, Franklin Delano Roosevelt, John Fitzgerald Kennedy, Harry S. He didn't have one either. I mean, the stuff you learn here is amazing, you got to admit. John Adams, on March 5th, 1770, an incident occurred outside of the Customs House in Boston. There was an argument or conflict between a private and a boy. The private knocked the boy around a bit, and what occurred is the boy ran off and then brought a mob back with him. And there was a confrontation between the mob and a group of British soldiers which were called out of the barracks. When it was all over, shots were fired. 5 of the people from the city of Boston were killed, 6 were wounded. The soldiers involved were tried for murder and were looking at the death sentence. One of the main persons trying to obtain the prosecution of these soldiers was Samuel Adams. And it's somewhat ironic that his cousin, John Adams, wound up defending them, along with another lawyer by the name of Quincy. The long and the short of it is this. The public cried for retributions. The public cried for these British soldiers who were so hateful in this community to be prosecuted and executed as these patriots were killed or slaughtered in the Boston Massacre. The facts weren't there, though. As it turned out, this was nothing but a mob. So John Adams had the very difficult job of defending these British soldiers in this community with a jury of people from Boston. He was successful in this defense. And he was successful because he was able to obtain the testimony of a particular witness. One of the gentlemen who was killed was by the name of Carr, and he died, but he gave a deathbed statement to a doctor by the name of Dr. John Jeffries. Dr. John Jeffries was one of the most prominent citizens of Boston, and his testimony was taken as the truth without question. And here's the Q&A. Were you Patrick Carr's surgeon? Answer, I was. Question, was he, Carr, apprehensive of the danger? Answer, he told me, he was a native of Ireland, that he had frequently seen mobs and soldiers called upon to quell them. And he had seen soldiers often fire on the people in Ireland, but had never seen them bear half so much before they fired in his life. Question, when had you the last conversation with him? Answer, about 4 o'clock in the afternoon, preceding the night on which he died, and he then particularly said he forgave the man, whoever he was that shot him. He was satisfied that he had no malice, but fired to defend himself. One of the great closing arguments was that of John Adams, who had no middle name, we all now know. He stated or concluded, not exactly the conclusion, but close to it, his lengthy closing argument. I will enlarge no more on the evidence, but submit it to you. Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. Nor is the law less stable than the fact. If an assault was made to endanger their lives, the law is clear. They had the right to kill in their own defense. If it was not so severe as to endanger their lives, yet if they were assaulted at all, struck and abused by blows of any sort, by snowballs, oyster shells, cinders, clubs or sticks of any kind, this was a provocation for which the law reduces the offense of killing down to manslaughter, in consideration of those passions in our nature which cannot be eradicated. To your candor and justice, I submit the prisoners and their cause. The law, in all vicissitudes of government, fluctuations of the passions, or flights of enthusiasm, will preserve a steady, undeviating course. It will not bend to the uncertain wishes, imaginations, and wanton tempers of men. I've gone through these, lawyers, and I think probably what you're thinking is, well, yeah, most of these cases were losers. I didn't go to law school to lose cases, my friend. What are you trying to tell us? What are you trying to inspire us to do? Well, I'm mindful of another lawyer by the name of Sam Houston. You don't think of him as a lawyer, but he was. Sam Houston enjoys one of the unusual, I guess, positions in history. He was the only person elected as the governor of 2 states. He was from Tennessee, and he was elected the governor of Tennessee, and then he went to Texas, where he became a great hero in the war for Texas independence and became elected to the governor of Texas. His main effort in life was to take this independent republic of Texas and make it part of the United States, part of the Union. In 1858, he was elected governor. And in 1861, there was a movement in Texas to join the Confederacy. So we have this situation where Sam Houston, who had spent his life trying to get the state of Texas into the United States, now the legislature wanted to have it taken out. Sam Houston refused to take an oath to the Confederacy. And so Sam Houston was, as a result, evicted, whatever that means, evicted from being governor of the state of Texas. He left Austin, capital of Texas, and went back to Galveston. And while on the way, he was asked, why could you do this? How could you do this? All of Texas wants to join the Confederacy, and we will be successful. Part of the thing you've got to understand is the Confederates believed themselves morally superior, militarily superior to the North. But he said this to the crowd. Let me tell you what is coming. After the sacrifice of countless millions of treasure and hundreds of thousands of lives, you may win Southern independence if God be not against you. But I doubt it. I tell you that while I believe with you in the doctrine of states' rights, the North is determined to preserve this union. They are not a fiery, impulsive people as you are, for they live in colder climates. But when they begin to move in a given direction, they move with the steady momentum and perseverance of a mighty avalanche. And what I fear is they will overwhelm the South. And later, he was asked about the shame of being evicted, or having his office taken away. And he said this: a man who fights for what he believes in and wins is a fortunate man indeed. The same man who fights for what he believes in and loses is no less a man because he lost. And there will be those who will look back and say he was a far greater man when he lost than when he won. So, I'm afraid I haven't used up all my time, which is concerning to me. The only thing I would say is this. I consider myself, and I often brag about being the luckiest lawyer in America. Why am I lucky? The answer is simple. I get all the good clients. And what I say when I get all the good clients is I think those of us who practice law, I mean really practice law, we deal with people in difficult straits. We deal with the outcasts of society. We deal with people who have not measured up. We deal with people who are in many ways not loved. They are the strangers in society. And if I may, there are two scriptural references to this that I like to fall back on. One is Deuteronomy 10. In Deuteronomy 10, when it says the essence of the law, this is stated: for the Lord your God is God of the gods and Lord of lords, the great God, mighty and awesome, who shows no partiality nor takes a bribe. He administers justice for the fatherless and the widow and loves the stranger, giving him food and clothing. Therefore, love the stranger, for you were strangers in the land of Egypt. And then there's Hebrews 13, which says this: do not forget to entertain strangers, for by so doing some have unwittingly entertained angels. So folks, I haven't used up all the time. I don't know what to tell you on this. I expected this to be much longer than it was. I've never done this speech before, and I expected it to be longer. So you want to ask questions, make comments, talk about lawyers that you respect. Thanks, you're not doing me any good. Yes, sir.
Never practiced criminal law, so I don't know how it's done at all, but I can see that you have defended some people who have not been particularly well received or well regarded in the press as their trials approached. And you have to put aside personal feelings to do the job as you see it needs to be done on behalf of these people. Do you ever have thoughts afterwards, or even during the process? You say you remain loyal to your clients, so I'm not asking you to betray any feelings you may have had, and maybe you've never had any doubts about your clients, but it's got to be a difficult thing to do.
I think the only reason, right, first of all, the answer to your question is a flat-out no. I've never had regrets of defending any particular client. I believe my job, and I think it's interesting that you bring that up. We call it in my business the question. And the question is how do you do this? I often, when I meet with a client, the first question I ask them, do you know what my job is? And they, to get me off, to do this, whatever. I said, no. Here's what my job is. You are now in the process, you're in the criminal justice system. I like to think you're in a big, dark, deep tunnel or tube. And the criminal charges against you are what you think about when you wake up in the morning. It's what you think about when you go to bed at night. It's what you think about when you go to church. It's what you think about all the time. You're obsessed with it. The world is closing in on you as you're going through this tube. My job is to first of all tell you, you will come out the other end. And my job is to get you out in the best shape I possibly can. And that means it's not my job to change your life. It's not my job to yell at you for what a fool you were, for what you did. It's not my job to discipline you. It's not my job to concern myself with the public or what the public thinks of you or me. It's not in my field of vision. And so when I approach it in that way, I've never had any regret for anything I've done. That's the way it works. And it's good that there are people who will do this. See, one of the things, people don't really get it, and I didn't get it for a long time, this concept of it's important that everybody gets a defense. All right, let's assume we have these lawyers, William Henry Seward in New York, or John Adams, who defended these people. You see, in any given judicial environment, if there are no Frederick Akins, William Seward, then things happen which shouldn't happen. But if there's just one, in other words, if the police in any community know that if we abuse someone's rights, this one person may wind up across the table, we'll have to answer for it. It changes everything. And so I like to think, I aspire, don't always get there obviously, to be that person. Do you see what I mean? Am I making any sense to you? But I have no qualms about any defense I've ever had. And if my clients are, and there's also a misconception which people have about guilt or innocence. The idea is that guilt or innocence are black and white clear. That's not what's really involved. I always tell my clients there are three categories of clients. There's some that are the pure as a driven snow. They have the wrong person, absolutely innocent. And if you get one of those clients, you hope they can pay you. The second thing is a client who's guilty as can be, is really into it very deep. And the third, which are the vast majority of clients, is clients who are guilty of something, but not what they say they are. And so I always tell my clients I can help all of them. I have something in my little bag for each one of them, including the person that's guilty of sin, to get him through it or her through it as best I can. There are, things that we can do. I'm sorry if I'm going on too long. Thanks for the question, though. I needed the question. Anybody got some more questions? Comments? Yes, sir.
Who's guilty of sin? Have you ever been in a situation knowing that where you had to go before a jury and argue his innocence and ask that he be acquitted?
One time, And that was a DUI case where we had a technical legal defense based on a search and seizure question. And we filed a motion in front of Judge Dillon. I know Kurt probably remembers Judge Dillon. He was very pro-prosecution. When I used to be a prosecutor, we used to say, you don't have to sum up for the Commonwealth, Judge Dillon. We'll take care of that in this charge. And, but in any event, Judge Dillon denied my motion to suppress. Now, in order to preserve the appeal, which I needed to do, I had to, I mean, the guy had a high blood alcohol. In order to preserve our right to appeal, I had to try the case, and my client had to be found guilty. So I went to go non-jury. I was just going to sit there, let the police officer testify, and I wasn't going to put any evidence on. Judge Dillon said, no, I'm going to make you try this in front of a jury, because he knew it would do it. So I got up and I did the best I could, stumbling around, but I laughed. And the jury laughed too, but they found my client guilty. But that's what I had to do. So you asked me, did I ever do that? That's the only time. There's often, see, once again, often the type of things that you're trying, for example, are not trying whether someone's guilty or innocent, but rather talking about degree of guilt. I had a case recently where my client was prosecuted for first-degree murder, and I truly believe he was not guilty of first-degree murder or third-degree murder, but he was guilty of involuntary manslaughter. And my argument to the jury was not that this man is innocent of any wrongdoing. He should be found guilty, but guilty of involuntary manslaughter. The jury found him guilty of third-degree murder. I think that was an injustice. I appealed it, and it's currently in front of the Superior Court. Am I making sense?
Sure. Now, from an ethical standpoint, similar hypothetical, would you ever put yourself in a situation knowing the client was guilty and try a case in front of a jury and ask for his innocence?
I don't ask for innocence.
Ask that he be found not guilty.
I ask that he be found not guilty. In other words, what I'm arguing, we're not arguing my opinion. It's unethical for me as a lawyer to state what my opinion is. I only talk about the evidence. This is what the evidence shows. It's not unethical for me to say that the Commonwealth has not presented evidence showing that my client is guilty. I don't argue innocence. I don't say my client is innocent because I believe that violates the canons of ethics. I don't know if I'm making sense to you. It's a hard distinction, but not if you're in it. The one thing that I guess that I do that a lot of lawyers don't do, I say there's one place I will not put you on the stand to commit perjury. I can't do that. And so if you want to testify or make up some story about what happened, I ain't your huckleberry. So and I think that I'm perfectly correct in doing that. There is a situation where you can, as a lawyer, they call it where you can put someone on to do a narrative. And a narrative is where you just have them get on and testify and you don't ask them any questions. I've never had to do that. Never had to do that. Anything else? These are really good questions. Let's not stop now, folks. Give me the hot seat. Come on. You can do it. You can do it. Yes, sir.
Let me ask you this, and Mr. Pappen made an inference to this also about the bench in general, about some judges that don't seem to be happy in their position or not good models for the general public, maybe irritable or impatient with the lawyers and the parties in front of them. Do you feel that the bench has changed over time, or do you think the same quality of individuals that are judges are the same today as they were 10 years ago, 20 years ago?
With me, it's 40 years ago. And the answer is no, I don't think they're the same.
And why not?
All right, I'll say exactly why. Because 40 years ago when I started practice, most judges with whom you're trying cases or who in front of you're trying cases, or I don't know if that came out right, were trial lawyers. They tried cases. They had had clients. They had gone through the process at that level. You have people now who are running for judges who have never tried a case. I always think it's interesting to have a judge tell me, this is how you try a case, or this is how you deal with your client. We know damn well they've never had a client. And they start telling you what to do and so forth. One of the glorious parts of getting old, I found that my relationship with judges changed as my hair became grayer and thinner. I found that I had a different reaction to judges. You start to not caring so much. When a judge starts yelling at you, you start yelling back. But in any event, I think that what's different is that they haven't really tried cases. And they come out of law school and they want to be judges. And I think that you ought to be a lawyer for a while before you become a judge, so you really understand it. They don't make good decisions, and they're too concerned with it. Do I think the quality of the bench has deteriorated? Yes. Maybe that's because I'm older now and I see things that I didn't see before. I don't know. There's still some wonderful judges.
Right.
I always say this. You run into all kinds of judges. A lot of them are bad. You run into someone who is ill-tempered on the bench, just nasty. You run into people who are not very smart, but think they're smart, and that's troublesome. Or you run into judges who are smart but can't tolerate anybody that's not as smart as they are. You run into judges who are lazy, who don't work, who come in at 10 in the morning and leave at 3 in the afternoon. You have judges who don't prepare. You have judges who simply don't care, that are doing something on the bench when you're doing it. I've actually been in front of the Superior Court and almost yelled out, would you look at me when I'm talking to you? Do you understand that there's all of these? But every once in a while, you'll go into a courtroom with a judge you haven't been before, and you'll find that the judge is attentive, very bright, knows your case inside and out, wants to do what's right, and you realize that they're going to make the right decisions on every one of your objections. Whether you're right or wrong, they're going to be right. And on top of it, they seem to be a genuinely good person. And you know what I say when you have that kind of experience, when you go into a courtroom like that? It's a glimpse into heaven. It's just like, I remember I had a case in Venango County, and the judge that I had was not a bad judge, but he just let the prosecutor run roughshod. And so I went up to try a jury trial. It was a very difficult case. And I walk into the courthouse, and there was a judge. The court administrator said, this judge is not going to be on your case. It's going to be another case, another judge from another county who I'd never heard of. And I thought, oh, man, here we go. We get into chambers with this judge, and it was like, this guy was very bright, very smart, wonderful. And I remember I walked out of that courthouse that day, walking on air. I had an experience like that last week, and I'll say who this guy's name was. I was up in, a week ago, Smethport, that's McCain County, and we have a very difficult case. And I understood that the judge was going to be the president judge, who I didn't know anything about. And they said, no, he had to recuse himself, and they're bringing in another judge. The judge's name was Cleland. Now, Judge Cleland, if you don't know his name, he's the trial judge of the Sandusky case. He was the trial judge in so many of these big corruption cases. We get into, with Judge Cleland, we had a pretrial conference. It was a glimpse into heaven. Everything, this guy was such a pleasant man and knew so much. He was very well prepared, knew the case. We're arguing for summary judgment. Well, not summary judgment, a habeas corpus motion. We moved for habeas corpus. And he said, that won't be necessary. I'm familiar with the law, and I've read this case. Your motion's denied. And we talk about it, that he said, there's no point in writing a brief. But it should have been denied. I'm not here trying to say, damn it, I should have won that motion. So I hope I've answered your questions. Anything else? You're not going to let me off the hook this easy. Come on. Come on, you can do it. Riddles, anything. Well, I don't know what else to tell you guys. We'll tell Angela we went through the break, I guess. Angelo is in here. There's our timekeeper back there. Where's Angelo? Anybody else want to make any comments about the legal system? Yes.
I just have a question. I'm really not familiar with what happened in Texas, and I was curious. You said that they didn't join the Confederacy.
Yes.
So what did they do?
No. He didn't want to join the Confederacy.
Then
They did. He was a block. He blocked them from joining because he wouldn't take an oath to the Confederacy, so they got rid of him. They joined the Confederacy, and what happened was exactly what he said was going to happen.
That much I do know.
Okay, it was bad. It was bad.
What happened to him? Did he move back to Tennessee?
No, he stayed in Texas, and I should have had that information, but I don't. Anything else? Yes.
Did you ever teach history?
Did I ever teach history?
Yes.
I wanted to be a history teacher instead of a lawyer. But no, I never did. I like history. Do you know why we should study history, everybody? Why we should? What? It really doesn't. We should study history because they're damn good stories. And if in reality is much better than what you get. I always say this. They're teaching, sex education in our high schools. If our secondary schools do to sex what they did to history, we'll become extinct. Because history is just a wonderful subject. It is. Anything else? Any other comments? Kurt, do you have any comment for us? I know Kurt for many years. So nothing. Folks, I don't know what else to do with you. I just didn't think that I would get finished this quick.